welcome to Short Circuit, your podcast on the Circuit Courts of Appeals. My name is Patrick Jaicomo. I am a senior attorney at the Institute for Justice, and today we are coming to you live from the Law Student Conference 2024. And what you just heard was the joyous expression of some of the brightest young legal minds in America who are here to watch me and my colleagues, Michael Bindas from Seattle and Katrin Marquez from Miami, talk about a couple circuit court decisions. This morning we have some very exciting topics, including insurance coverage and
indemnification as well.
Oh, yes, also indemnification and defense. And Katrin will be explaining the ins and outs of how all of that works.
She will not.
And then we will be talking about qualified immunity in a much sadder case. But let's get started with my colleague Michael, who is going to tell us about the 11th Circuit's decision in Snell versus United Specialty Insurance Company and what that can tell us about the future of textualism.
Sure. So this case is not really notable for its subject matter. As Patrick alluded, it's a dispute over an insurer's duty to defend and indemnify the insured. It's not too notable for the majority opinion, which is pretty straightforward. But man, Judge Newsom's concurring opinion is something. The quality of the writing is great, which is not surprising. Judge Newsom's a great writer. It's got comedy all over, which is not surprising because Judge Newsom is known to put some humor in his opinions. But the content, what his concurring opinion proposes, is something of a surprise. So let's set the table here first. The case was brought by a gentleman named James Snell, who is a landscaper. He had been hired by a family to install an in-ground trampoline in their yard. And it involved some kind of landscapey tasks. There was tree removal, shrub removal, and then, planting of some trees and such, setting up a sprinkler irrigation system. But it also involved site work for the trampoline itself. So digging a pit to put the trampoline in, building a retaining wall, a wooden cap around the perimeter of the retaining wall, and assembly of the trampoline itself. So anyway, Snell does this work. And then the family for whom he had done the work wound up getting sued by the family of a girl in the neighborhood who was playing on the trampoline and apparently did a face plant on that wood perimeter around the retaining wall and suffered some injuries. Initially, it was just the family that was sued, but then the other family that brought the lawsuit added Snell to the case as well, and essentially brought a negligence claim against him. So Snell at that point did what he would be expected to do. He notified his insurer, and he expected that they would appoint an attorney to defend him and ultimately indemnify him in the event that there was an adverse judgment against him. But the insurer refused to do that. It pointed to an endorsement in the insurance policy that limited coverage to specified operations, and the one specified operation was the performance of landscaping. And the insurer took the position that, look, the allegations in the complaint are that injuries resulted from building the retaining wall and installing the trampoline and the wood cap around the trampoline. That's not landscaping. And moreover, the insurer pointed to the fact that Snell was asked on the application for the insurance policy whether he did any recreational or playground equipment construction or erection, and Snell checked no on that question on the application. But nevertheless, Snell sued the insurer after it denied coverage. He sued him in state court. The insurer removed to federal court, and the district court granted summary judgment in favor of the insurer. Snell appealed to the 11th Circuit. And the 11th Circuit's opinion is pretty straightforward. It notes that the existence to prove coverage is on the insured. It notes that the policy contained this endorsement limiting coverage to specified operations, which was specifically landscaping. It notes that there's a dispute between the parties about the definition of landscaping and whether the work related to the trampoline fits within that definition. But the court said ultimately it's not necessary for us to resolve that because under Alabama law, the application for the insurance policy is actually part of the policy itself. It's this kind of this weird statutory quirk and interpretation of that statute under Alabama law. But because the application becomes part of the policy, and because Snell had checked no when he was asked, do you do any recreational equipment work, the court said that, we don't even need to reach this question about whether the work was or was not landscaping, because he disclaimed that he did the work that was alleged to have caused the injury. So pretty straightforward analysis. But now enter Judge Newsom's concurrence.
Let me just pause there, because ultimately what we're talking about, right, is the definition of landscaping and whether this action, that putting of a trampoline into the ground, constitutes landscaping. That's the textual question that we're grappling with. So normally not something that listeners to this podcast might be particularly interested in. And since we're all friends here, folks, I can tell you this is feeling like mother's milk from my previous career in private practice, where I spent far too much time fighting over insurance coverage and going through the various sorts of machinations that we see in this opinion, where you're reading dictionary definitions to assess the ordinary meaning of the word landscaping and deciding, well, which dictionary definition is it? And, is this one better than that one? And what would the parties have understood the meaning of landscaping to include? And then reading the definition and thinking, well, that might not actually be what I think of as landscaping. So how can I massage this in such a way that it's not actually landscaping? And that is what I think much of Judge Newsom's concurrence is about to get into here. And we're going to talk about that. But I do want to say, since we're on the topic of textualism, this Alabama statute that brings in the insurance application itself seems to violate one of the textual canons of construction, the last antecedent rule. And as Judge Newsom also points out in a footnote, it sure seems like the phrase application of insurance only includes applications that are part of the contract, which this was not. But nevertheless, let's talk about artificial intelligence.
Sure. So here's where it gets interesting, and you'll have to forgive me here, because I'm going to read a little bit, here and there from Judge Newsom's opinion. So bear with me, but it's worth the read, I assure you. So he begins his concurrence by saying, "I write separately, and I'll confess this is a little unusual. Footnote, even for me." Simply to pull back the curtain on the process by which I thought through one of the issues in this case, and using my own experience here as a backdrop to make a modest proposal regarding courts' interpretations of the words and phrases used in legal documents. Now, unlike Jonathan Swift's modest proposal, Judge Newsom's is not satire. He's being quite serious. Nor is his modest proposal quite as shocking as suggesting that the poor sell their babies to the rich for food, but it's still pretty shocking, as even Judge Newsom seems to recognize. He says, "Here's the proposal, which I suspect many will reflexively condemn as heresy, but which I promise to unpack if given the chance. Those, like me, who believe that ordinary meaning is the foundational rule for the evaluation of legal texts, should consider whether and how AI-powered large language models like OpenAI's ChatGPT, Google's Gemini, and Anthropic's Claude might inform the interpretive analysis. There, Judge Newsom says, having thought the unthinkable, I've said the unsayable." So he goes on to explain that, as Patrick alluded to, this is an ordinary meaning case, that really, at the end of the day, it seems to come down, although because of that quirk in Alabama law, it doesn't quite come down on this, but it deals with the ordinary meaning of the term landscaping, and specifically whether installation of the trampoline, the retaining wall, the cap around the retaining wall is or is not landscaping. Now, Judge Newsom recognizes that, strictly speaking, you don't have to resolve that question given the quirk of Alabama law that says the application is part of the policy. But he says that off-ramp to kind of dodge the textual question wasn't apparent to him, wasn't obvious when he first started reading the briefs and preparing for argument. He says, in fact, that he spent hours and hours and hours laboring over the question whether Snell's trampoline installation project qualified as landscaping as that term is ordinarily understood. And it was midway along that journey, Judge Newsom says, that I had the disconcerting thought that underlies this separate writing. Is it absurd to think that ChatGPT might be able to shed some light on what the term landscaping means? Initially, I answered my own question in the affirmative, Judge Newsom says. Yes, Kevin, that is positively absurd. But the longer and more deeply I considered it, the less absurd it seems. And Judge Newsom gives us thought process here. He notes that he's what he says an unabashedly plain language guy. So he went to the dictionaries, as Patrick mentioned before. And he says Snell had offered up a buffet of dictionary definitions in support of his position. And Judge Newsom says his research found many other dictionary definitions that could cut kind of either way in favor of Snell or in favor of the insured. And he says it was, at the end of the day, impossible to discern kind of a controlling criterion for what landscaping meant. Did it include only botanical and other natural improvements to the property, or did it include kind of more structural type stuff? Did it cover both aesthetic improvements and functional improvements, or was it just concerned with aesthetics? And he says after languishing in this definitional purgatory for a while, he considered photos of the trampoline, photos, of course, that were in the record. And he says, I'm not particularly proud of it, but I'll confess that the photos affected the way I thought about the case. Nothing in them really struck me as particularly landscaping-y. The problem, Judge Newsom says, was that he couldn't articulate why. And visceral gut instinct decision-making, he says, has always given me the willies. So the judge says he was back to square one.
Can I pause right there and just say, so Judge Newsom's concurrence is very fun to read, and he has this giant buildup of why he's doing what he's doing that I actually think in some ways undermines the seriousness of the point that he's making, because as he builds up to it, as now having read it, I don't think that the suggestions he makes are particularly absurd. And so to start out by saying, I know this sounds crazy and absurd, but I think sort of poisons the well a little bit. But I think as he goes through this process is a very interesting insight, because I had similar experiences both when I was clerking and when I was working, dealing with these exact sorts of things, which you spend, if you don't come into public interest, folks, you spend a lot of your time doing this stuff as a litigator. And what he's talking about is exactly the same thing you do when you open a dictionary. So at this point, he's queried a couple AIs, and they've given him definitions that sound pretty good. Now he's looking at pictures and thinking, well, me seeing this, it doesn't seem too landscaping-y.
He hasn't turned to AI yet.
Okay,
he goes to the dictionaries. He goes to the photos.
But this is the thing that happens all the time. Is you're the interpreter and you're saying, okay, well, I'm supposed to look at a definition, and I looked at a definition, but it doesn't really jibe with my kind of vibe of what this word should mean in this context. And I think that is the hardest thing about the textual analysis framework that we're dealing with here. And so I think that, as we're going to talk about shortly, the AI thing did not strike me as a step too far, when you could either have a semi-neutral computer program that's spitting an answer back to you, or you can have a semi-neutral human being who wears a robe who spits the answer back to you.
Yeah, it did strike me as, maybe more shocking than it did you. I don't know if that's because I'm 10, 15 years older than you, and I'm the idea of technology gives me, in Judge Newsom's words, the willies, but much less using AI to inform judicial analysis. But, I don't know if that's like a generational thing, but it was kind of shocking to me. But anyway, so Judge Newsom goes to the dictionaries. That doesn't help. He goes to the photos. That doesn't help. And he says, and that's where things get weird, or got weird. He says, perhaps in a fit of frustration, and most definitely on what can only be described as a lark, I said to one of my clerks, I wonder what ChatGPT thinks about all this. So the clerk ran a query, what is the ordinary meaning of landscaping? And I won't read that definition that ChatGPT spat out, but it's in the opinion. And Judge Newsom says, ChatGPT's explanation seemed more sensible than I had thought it might, and definitely less nutty than I had feared. And he says it squared with my own impression, informed from my own experience writing, reading, speaking, and listening to American English in the real world, that ordinary people might well use the word landscaping to include more than just botanical and other natural improvements, and to cover both aesthetic and functional objectives. And then Judge Newsom explains that he went on to ask ChatGPT the ultimate question, is installing an in-ground trampoline landscaping? And ChatGPT's response suggested that it just might be landscaping. Now, ultimately, again, none of this mattered to the decision, given that disclaimer on the insurance policy application that Snell did not do any recreational equipment installation. But the process, Judge Newsom says, was a valuable one, if only because it got me thinking about what was to me a previously unimaginable possibility. Might large language models be useful in the interpretation of legal texts? He says, having initially thought the idea positively ludicrous, I think I'm now a pretty firm maybe. At the very least, it seems to me it's an issue worth exploring. And then he goes on to explore it. He talks about some of the benefits and some of the risks of using AI to inform ordinary meaning analysis. And maybe we can talk a little bit about that, but maybe I'll push pause right there and see, Katrin and Patrick, if you guys have any thoughts so far.
I mean, I definitely have thoughts. Not about insurance, though. All about AI. So I think I had an instinct somewhat similar to Patrick, but maybe even going further, that not only do I not think it's absurd to think about this, I actually think it's absolutely necessary, and that now is the time to do it. Because I think AI is just going to increasingly become a tool for attorneys, and we need to spend time going through the process of figuring out how we're going to use it and where the value is. So a case like this, where it ends up actually not mattering, is a good place to start. I mean, he wasn't modeling this behavior, but essentially doing that, having this practice of thinking through how can we use this tool, what's it beneficial for? Because, I mean, as he's discussing some of his considerations, part of what he talks about is you need to think through what prompts you use, which models you're going to use. And I think those are important questions for lawyers to really start grappling with as this becomes a more common tool. Obviously, there's these large language models that you can use for many different things, but even our own legal research tools are increasingly relying on AI, so we really need to stop and think through it. I found this very useful just in terms of how one judge thought through it. Obviously, not every judge is going to have the same process, but just seeing it, I think, is beneficial. Now, that actually could go into a whole other topic about what the purpose of a judicial opinion is and what genre of judicial opinion is, or whether this should have been a law review article. But in general, I found it very helpful for that purpose of just recognizing that this is an issue that's emerging in our industry and we really need to think through it.
So going back to your point, Michael, about the age difference maybe being why you're concerned about AI, and I'm less concerned, and Katrin seems in the less concerned category too.
For the record, I am concerned. I just think it's irresponsible not to think through it because it's coming no matter what.
And I think maybe the explanation could also be like the level of cynicism involved in judicial decision making, because when we're talking about ordinary meaning, textualism, interpretation, things like that, really what I think we're trying to get at is sort of the democratization of the words, because we're not looking at a contract between Michael and Patrick and what did Michael and Patrick understand the word to mean, because if they wanted to do that, they could have defined the word. And that, of course, in these insurance contracts happens all the time. But we're talking about ordinary meaning, which is what would an ordinary person think this word means. And so like one way of doing that is looking at a dictionary, and we're going to talk about that here in a minute, and there are drawbacks to doing that, but that's clearly the prevailing standard to do this. Another might be these language models through AI. Another might be just taking a poll. Let's see, we got like 50 people in this room. How many think that installing a trampoline into the ground of someone's backyard falls within the meaning of landscaping? Okay, how many don't? Yeah, pretty
50-50.
even split.
Yeah.
Pretty even split. I think the yeses might have had it, but either way, I mean, it's hard to defend why a judge reading a dictionary would be better than an AI model as long as it's, sufficiently neutral, or me just asking a group of 50 people, does this word mean this thing in this context? And so I think that's what this is, a very interesting exercise of pulling back the veil on how textualism works and why we should care about it working. I mean, one thing you could take away from this is you could say, well, I think textualism is a bad interpretive model because these things have revealed themselves.
Yeah, no, these are great points. And as I mentioned, Judge Newsom goes through what he sees as the benefits and risks to using AI and covers a lot of this territory. He points out that large language models train on this kind of massive body of usage on the internet and, usage of terms. And I'm speaking way outside of my kind of comfort level here, but he says they train on a mind-bogglingly enormous amount of raw data taken from the internet, and those data run the gamut from the highest minded to the lowest, from Hemingway novels and PhD dissertations to gossip rags and comment threads. So, just the sheer volume of usage and ways that language is used, so long as it's gathering that data in a kind of neutral way, I suppose is perhaps a much better reflection of how terms are used ordinarily than consulting dictionaries. And he mentions the fact that judges are often accused of looking at competing dictionary definitions and what he calls comparative weighing of those definitions. And like advocates, perhaps relying on the definition that most supports the conclusion that they want to reach in the case, which is obviously a problem. And he sees AI as much less, the potential for much less mischief in that regard. And, getting back to the generational thing, I think the thing that struck me after I read the concurring opinion was how it relates to the idea of corpus linguistics. I know we've got at least 3 BYU folks in the crowd here, and BYU has been pioneering the area of corpus linguistics in constitutional analysis, and that is something I'm very comfortable with. But as Judge Newsom points out, corpus linguistics has its own potential problems as well in terms of how do you define the corpus, what works go into it. There's some editorializing in that, whereas he sees AI as being less risky in that regard. So despite my initial discomfort and surprise at this, I think I started perhaps to come around. I'm not sure if I'm quite there yet, but it certainly raises some interesting questions.
I think this could have something to do with the bias that you might have towards the meaning of the word landscaping and how important that's been in your life.
Yes. I do like the fact that Judge Newsom talks about his own landscaping experiences and apparently releveling his backyard and such.
I would say I actually found that example extremely helpful because in the rest of the discussion, the examples that were brought up about how you distinguish what is and isn't landscaping, none of them hit. But that one, I'm like, the fact that it was very much something that you do for structure and not at all decorative really helped me understand what his concerns were, because I actually don't understand whether that's a structural construction thing that you do or whether that's landscaping in a way that the other examples just weren't as helpful for me.
Yeah. Yep. Yeah. So, I mean, I really commend it to everyone. He talks about, like I said, some of the risks as well. One of the risks I found kind of most persuasive, or at least something to think about, is this idea that AI is only drawing from online sources, right? Either content that was created to be online or that was created offline and later digitized. And he talks about that certain communities, certain demographics might not be reflected. Their usage of terms may not be reflected if they don't have as much a kind of an input into online conversation, and that's certainly something that we need to be mindful of and think about if we do start incorporating this as another tool. And to be clear, Judge Newsom is not suggesting that this should be the tool for engaging in ordinary meaning analysis. He's just positing that perhaps this is one tool to add to the others, the canons of construction and the other types of tools that you would typically turn to in plain meaning analysis.
Yeah, this is actually why I thought the concurrence was so interesting, was because in having this discussion about whether AI serves the purposes of textual analysis, it makes you realize, well, what is textual analysis about? Is it a useful mode? Is it not a useful mode? What are the drawbacks? What are the pros and cons? Because as you say, right now, the system is, by and large, read a couple dictionaries and then have a person with advanced degrees just decide what feels more right to them and then sort of explain how those words commend that conclusion to you. But, and Judge Newsom points this out, dictionaries have all the same problems that the language models have, which is
Dictionaries are incredibly unhelpful. They don't even have the context.
Well, just imagine. I mean, do you think the kind of person who becomes a lexicographer is reflective of normal everyday people and their relationship with language?
The lexicographers I know are.
Sure, of course, right. All of my lexicography friends, they are the exception.
Lexicographers.
But the point is, I mean, language develops over time, and language is kind of what we all use it for, especially English, because there's not some government-sanctioned body that tells you what English means or doesn't mean. It's
There's
something.
no Real Academia.
See, exactly, and that's what makes this so interesting and so important. And the question will be, I think, yes, of course, can judges who tend to be on the more conservative side as far as people behaving goes ever get to the point where they say, like, actually, this would be better left in the hands of essentially what is a computer program, which is kind of funny because in a lot of ways, like, that's sort of the idealized fantasy of textual analysis, is that you can just put these into a computer program and it spits out the correct answer of this is what this word means in this context. And that's how we settle your dispute in a fair way. And then we don't engage in blood feuds in our society. Like, that's really the whole point of the legal system in a lot of interesting ways.
Textualism as a theory is you're always applying an algorithm to find the answer, even if the algorithm isn't a computer-based algorithm, it's just a processing.
Right. The point is that you have the same results being spit out without the bias of, well, I want them to be something that they're not. And so I think that this is a very useful study of all these things and what the future of this might be. And, you know, what I thought by the time I was reading the end of this and having read a lot of insurance contracts, which are just full of definitions and exclusions and riders and endorsements and impossible to read. I mean, even if you look at the majority opinion here, you have to piece together like 7 different documents to figure out what any given paragraph means. I thought, well, you know, the first step in this potential would be an insurance contract that says, like, disputes over the interpretation of this contract are governed by
AI?
Some AI query through this particular AI program. And we will put in, like, the query will be, we put the entire contract in, including all these documents. And then the question will be, what is the meaning of this and whatever. You could contract around this and make this happen. I think the sort of dystopian concern on the other side of it, if this just became the way judges actually interpreted things, whether or not you agreed to it, is that, especially in the context of litigation against gigantic corporations that might be the same corporations that are deciding how these algorithms inside of ChatGPT work or whatever the AI model is, that there could be a lot of room for gamesmanship in a way that nobody else would be able to discern from the outside.
Litigating against Google.
Exactly.
And they're the ones that are running the program.
Exactly. So that would be like litigating against the government.
Yeah. What a segue.
Yeah. So on that point, let's shift from private law into public law and talk about qualified immunity in a very sad case out of Katrin's hometown,
Yes.
Miami, the second Miami in America.
How dare you?
After Miami in Ohio, where the word Miami is actually from.
How dare you?
So let's and I do want to warn our listeners. This is a very sad case about a pet, and so 1, be warned, and if you want to turn it off now, we understand. But 2, please apologize. We'd like to apologize in advance for the gallows humor. This is one of those, if you don't laugh, you're going to cry situations. So let's talk about what happened in the sad story of Niles the dog.
Yes. So the sad story of Niles the dog is the case Plowright v. Miami-Dade County. It's sad, but it's hopeful in a big picture sense. So let's stick with that part. So Sylvan Plowright is a man that lives in Miami-Dade County, and he owned a lovely American bulldog named Niles. He loved Niles. One evening, Plowright called 911 to report someone that was trespassing on a vacant property near his home. He called 911, so what happens? 2 police officers show up. The police officers that responded to the call, which were officers Rondon and Cordova, approached Plowright's home through a dimly lit driveway, and when Plowright came out to greet them, they drew their guns on him and started shouting at him. Now, remember, Plowright is the one who called 911 to report a trespass. Like, this man has done nothing wrong. He is just going out to greet the cops to explain what's going on. As this is happening, Niles, Plowright's bulldog, enters the scene, and the officers order Plowright to get control of the dog, but before he's able to do so, one of the officers, Rondon, tases Niles and sends him into shock. Now, at this point, Niles is already down from the taser. He is in shock. He is not really doing anything. He's whimpering, poor thing. But what happens, the other officer, Officer Cordova, decides to shoot Niles at least twice, killing the dog for no reason. Now, it's true that in the allegations in the complaint, it says that Niles had been barking when the officers first approached, but he was just barking. Also, by the time he was tased and then shot, he had been like wagging his tail and just been a happy little dog. And obviously, by the time he was shot, he had already been incapacitated because of the taser. And so Plowright is devastated watching his dog die. And at that moment, the cops are ordering him to the ground. It's a terrible scene all around. So those are the facts of the case. So they're pretty straightforward. And so Plowright subsequently files a federal lawsuit. He brings 4 claims. One of them is a Section 1983 claim for unreasonable seizure through excessive force, and that one's against Officer Cordova. He is the shooter. He also brings claims for intentional infliction of emotional distress against both officers, negligence and negligent training and supervision against Miami-Dade County, and negligent supervision against the Miami-Dade Chief of Police. So this is at the Southern District of Florida, where I live. And the district court dismisses the original complaint in the case, but allows Plowright to replead his claims. He does so. In the new amended complaint also includes an appended article from a newspaper discussing 5 family pets, including Niles, that the Miami-Dade County PD had shot since 2018. And the article also quotes also mentions that the department has no standard dog training program, and quoted a senior officer within the Miami-Dade Police Department saying that they needed to bring in experts to, quote, develop a curriculum that we can utilize, because the department, this is an issue that keeps coming up and cops are not addressing it well. So for the purpose of this discussion, I'm going to focus on the Section 1983 claim because it's classic qualified immunity. So he brings this claim, of course. The cop, Cordova, says, it doesn't matter, you can't recover against me because I am entitled to qualified immunity. Now remember, usually the test for whether someone gets qualified immunity is whether there is a right that has been violated at all, and whether that right is clearly established such that no reasonable officer would have known, such that any reasonable officer would have known that they were violating someone's constitutional rights. A lot of cases, unfortunately, a lot of meritorious cases end up dying in the clearly established analysis. But this is an exception, and that's why, even though it's very sad, there's actually something very nice here. So in terms of the first question about whether there is a right that has been violated, the 11th Circuit frames the question as, does an official violate the Fourth Amendment when he uses deadly force against a domestic animal that is incapacitated and incapable of harming anyone? And they say the answer is clearly yes. So they go through a quick but thorough analysis where they say the Fourth Amendment guarantees the rights to be, quote, secure in the person, houses, for someone to be secure in their person, houses, papers, and effects against unreasonable searches and seizures. Under Florida law, pets are personal property, aka they are effects under the Fourth Amendment, and shooting a pet interferes with a person's possessory interests. You are destroying the property. They buttress this analysis by mentioning that almost every other circuit has previously found that shooting a pet is a seizure under the Fourth Amendment. And they have this very nice long footnote where they cite cases from the 1st, 2nd, 3rd, 4th, 6th, 7th, 8th, 9th, 10th, and DC circuits. So if you're wondering, the only one missing from that list that is not the 11th Circuit is the 5th Circuit. But guess what? Even the Fifth Circuit is kind of on the list because they do have a case saying that, but it's unpublished, so it's not clearly established because it's not precedential, but they do actually have a case saying that.
Yeah, let's step back. Tell us how clearly established normally works.
So usually, for clearly established, if you want to show that the officer, the government official of several varieties, is liable, you have to be able to point to specific law that says what they are doing is a violation. So usually that is precedent from a controlling jurisdiction. So, sorry, I may go into my little rant.
Please. That's what we're here to hear, your little rant. You've got like 20 minutes. Let's go.
So the most common one would be if you can find a case within the circuit that is published, it is precedential, that has essentially the same facts. So in this case, it would be someone else had a dog that was incapacitated that was shot. Unfortunately, there has been some irrational reasoning where people say that, no, it has to be clearly established by the Supreme Court. Nothing else counts. I think that is ridiculous, especially as the Supreme Court takes fewer and fewer cases, and therefore there are fewer opportunities for them to be very specific. This is also a problem since courts tend to distinguish precedents that people cite on very minute factual differences that aren't really relevant. To take another example, there was a case where someone sicked a dog, someone who was lying down, I believe.
They were kneeling. Yeah.
Well, no, I'm talking about the one that was already established.
Oh, yeah, sure.
Yeah.
Sure.
So there was a case that existed that it was, if you sick a dog on someone that's lying down on the ground, that is a violation. Sometime later, someone brings a case where that happened, but they were not lying down, they were kneeling. And they said, oh, sorry, entitled to qualified immunity. These things are both very, very different, even though in both of them the person is incapacitated, can't really move around.
Yeah, to just give you another example of how the clearly established test works, there was a recent 11th Circuit decision where there was a case saying that you couldn't do certain things that had to do with inmate mail from the U.S. Supreme Court, no less.
Yes.
And the 11th Circuit said it wasn't clearly established because in that case, the things they were doing were to inmate email. And since mail
Totally
and email, yes, if you did for the younger folks, email means electronic mail. This was something that was established, I believe, in the early 90s. So that was enough for the 11th Circuit to say it wasn't clearly established. And I think that we talk about this quite a bit. This hair splitting or the rejection of hair splitting, which is what we're going to get into here, really makes the application of the clearly established test a matter of judicial grace. And so if you get a judge or a panel who wants to side for you, they can say this is sufficiently analogous. And if you get a judge or a panel that wants to side against you, they can split the salami so thin that there's just no way you'll ever get to a case. And so you could have a case exactly like this, and then this case come along and say, well, that case involved a pit bull, and your case involved a bulldog, and pit bulls are notoriously more dangerous than bulldogs, and so the cases are distinguishable, or something like that. It doesn't.
Niles as opposed to Miles.
Yeah,
Yeah.
right. Yeah, Niles could be. You could decide that was a very intimidating dog name or a very unintimidating dog name. Maybe the dog has a spiked collar or not a spiked collar. Anyway, just sitting here off the top of your head, you can think of some way to say, well, this case is different. The other thing that's worth clarifying, and I think this is interesting because the court doesn't comment on this, is that another way you can clearly establish the law is if there's not controlling precedent in your jurisdiction, you can rely on a consensus of the other circuits. And it's unclear exactly how many circuits are necessary for a consensus, but I think it is safe to say.
One would think every other circuit would be enough.
Exactly. And so the 11th Circuit could have just said that.
They could have, yeah.
But they went further. So what did the 11th Circuit do here?
Yes. So the 11th Circuit at the right that is clearly established analysis instead relied on a beautiful case from 2002 called Hope v. Pelser, which just has a very appropriate name because it gives me hope. So in Hope v. Pelser, the Supreme Court held, and I am going to quote this because I don't want to get it wrong, that officials can still be unnoticed that their conduct violates established law even under novel circumstances. That's because in those cases, a quote quote, a general constitutional rule already identified in the decisional law may apply with obvious clarity to the specific conduct in question, even though every action in question has not previously been held unlawful. So essentially the idea that there are some violations that are so obviously a violation that you don't need to be able to cite a specific precedent because any reasonable officer would know that what they are doing is wrong. And here, that should be obvious because it's obvious that the dog is property. And under the facts of the case, which remember involved the dog already being incapacitated because it was tased, no reasonable officer could have thought that the dog really posed a danger. Now, there could be other circumstances in which you think the dog could pose a danger, but here it was obvious that that was not true. The dog was already incapacitated, so you did not need to shoot it twice and kill it. Shoot it at least twice. We're not actually quite sure what the number is. And kill it in order for the unconstitutionality to be obvious.
So Hope proposes what we call the obviousness exception to qualified immunity. Mm-hmm. And the sort of twist that's not discussed at all in the opinion is that this was largely a dead letter after the Supreme Court decided it for about 20 years until a recent case called Taylor versus Riojas brought it back to life. And so now we're starting to see circuit courts across the country finally sort of do something with the obviousness exception, because before it was just kind of a theoretical off-ramp, but it wasn't often used. But now, ever since Taylor, we've started seeing it more and more. There's a case. The Taylor case itself was about horrific prison conditions, and the Supreme Court said you don't need a case. IJ litigated a case in New Mexico where a road-raging off-duty police officer chased our client home and pointed a gun at him in his driveway. And the 10th Circuit said, yeah, you don't need a case specifically involving a road-raging off-duty police officer pointing a gun at someone in their driveway to let this guy know, who, by the way, was convicted of a felony under state law, that what he was doing was bad. And so this is another one of these cases. And I think one of the things that kind of hits you as you read it, if you understand all that, is like, oh, wait, that means in every other case that wasn't what was being done when we were talking about qualified immunity? And the answer is that's correct. It was the court just splitting hairs and deciding if your dog shooting case is sufficiently similar to the earlier dog shooting case.
I mean, there's many, many, many frustrating things about qualified immunity, but one of the very frustrating things is that I think a lot of judges who talk about caring deeply about textualism use qualified immunity so often, even though, guess what? The text of the Constitution already has a test to deal with this. It is called the reasonableness aspect of the Fourth Amendment. It has a test built in. You don't need to rely on this atextual doctrine in order to protect cops. Courts are entirely capable of doing this analysis. They do it in every other part of the law.
Yeah, so let's talk a little bit now about what the court does with the other claims in the case.
With the intentional infliction of emotional distress, those claims actually do move forward with a similar analysis, but the other claims, not so much. Unfortunately, they do not hold the county accountable. With the claim against the Miami-Dade police chief, that actually wasn't argued on appeal. It was abandoned, and therefore it wasn't actually addressed in this opinion.
I do want to pause here on the intentional infliction of emotional distress discussion, because this is what I think illustrates what was so upsetting to this panel. And so you go and look at how that operates under Florida state law, which is very similar to most other states. And there are also immunities for that, but they don't apply here. We won't get into all that. But essentially the core standard for proving up an intentional infliction of emotional distress claim is that you have to show that the conduct was outrageous beyond all bounds of decency and odious and utterly intolerable in a civilized community, which, is a pretty high standard. And as many of you who went to law school may be aware of, typically the way the standard is formulated is if you told a normal person about what happened, they would proclaim outrageous, which, by the way, to pull back the curtain, is pretty much the ideal way that IJ finds our cases.
You could also ask ChatGPT if it was outrageous, right? Yeah.
You should try. You should definitely try. And so I think the discussion of this is actually going to show you why this was so clearly upsetting to the panel, such that they would say, we're going to find this to be an obvious constitutional violation.
they were horrible facts. Like, you are attacking a man's dog that is completely incapacitated. Obviously, it's so obvious to me. It feels like you don't need to say it.
This is the landscaping-y side of the analysis, where you're just like, well, I mean, it is, to be fair, the criticisms of the obviousness exception, which we've seen, recently in the Fifth Circuit, for instance, in Villarreal versus City of Laredo, are that, well, what the heck does that mean? Like, how do you pin that down? And I don't know that there's a great answer, in the same way that how do you pin down what's outrageous sufficient for intentional infliction of emotional distress? But this case and the others that we've discussed seem like wherever the line is, they're far on the outrageous side of it.
But I mean, the fact that things like claims for intentional infliction of emotional distress shows you that courts are capable of doing this analysis, that they do it in other contexts.
Our former colleague Clark Neely used to say that if he wasn't at IJ, he would set up a public interest firm to go after police officers who kill dogs, in their duties. And I guess this is proof of concept for his idea.
So often.
Now we know the runway is cleared across all the circuits at this point. The fifth is still like maybe on the bubble, but it seems like we can move forward with the assumption that you've got a very strong chance. Now
I was gonna say, once you have every other jurisdiction, maybe the fifth will go, but the fifth is fun. I don't know.
Well, now we have them all, so let's find out. And that takes us then to the question of whether you can sue the municipal employer, Miami-Dade County. Yeah, so I'll preface the way that Monell works is you have to show that the municipal employer itself violated the Constitution, which you can do through saying, well, there's a policy that's been formally adopted, or there's a pattern in practice sufficient to say that there's a policy, things like that. The policy can sometimes come in the form of negligent training or hiring.
Yeah.
And there are a couple flavors at play here, but I think functionally we're talking about a training claim.
Yeah, so remember how earlier I mentioned that in the second amended complaint, they had attached a newspaper article talking about the fact that there had been a series of these incidents. The court did not believe that was sufficient to establish a policy or practice of shooting dogs. Part of the reason was they thought that there was a temporal issue here, and that it was unclear at what point all of these cases that had been discussed in this article had happened, whether they had been before or after the Niles incident. Obviously, at least one of them was the Niles incident, so we know the timing of that one. But that in itself was not enough to establish that there was a policy or practice of doing this within Miami-Dade County.
Yeah, I mean, it's hard to imagine what else you could do in the normal course of litigation. I mean, when we bring cases, we spend a lot of time working up the background information, and so our complaints tend to be more thorough and substantial than a lot that you'll see. But I mean, it's clear that those shouldn't be the standard for the sake of how you apply these cases in normal practice. And it seems to me that a news article saying, hey, this sort of thing happens quite a bit, and I think there was also evidence.
There was a very senior person at the department who was saying we need to bring in experts to address this because it's a problem that keeps coming up.
You'd think that would be enough to move forward. I mean, I suspect that there has to be some amount of thought that, well, you're able to go forward against the officer, so do we really need to allow the lawsuit to also move forward against the employer? But, in a case where the outcome comes out differently on the individual claim, this sort of Monell analysis would then close someone out of court completely, despite this horrific thing that happened that definitely violated the Fourth Amendment, at least as alleged.
I'm curious what you guys think about the kind of ideological composition of the panel in the case, and was that surprising to you that they denied qualified immunity or not?
So I think this is actually a really interesting panel. So this panel is Chief Judge William Pryor, Judge Joe Pryor. Yes, there are two, and they have very similar names, unfortunately. And Senior Judge Marquez. What's interesting about them is that they're across the political spectrum. They're actually also across the geography of the 11th Circuit. One is from Miami, one is from Atlanta, and one is from Alabama. But what's interesting about them is that Judge Joe Pryor is what one would consider more of a Democrat. Judge Will Pryor is what one would consider fairly conservative. He was on one of Trump's shortlists. And Judge Marquez, I think, is more to the conservative side, but is considered somewhere closer in the middle. And here, there were no dissents. There was really no one that disagreed with the analysis, like it still applied. I think part of it is because the facts are so sad. It's very clear. Another thing, and I think this may be good to point out since y'all are law students, is the quality of the advocacy, I think, was important. So you don't get this so much from the opinion, but I was very curious about the panel because I thought it was an interesting one. So I was like, I'm going to listen to the oral argument because sometimes interesting things happen when you listen to the oral argument. And one of the fascinating things is the attorney for the county was horrible. She has a beautiful voice. She spoke with confidence, but the things she was saying was exactly what you should not do. So practice tip, if you're at oral argument and someone asks you a question, ask the question they asked you, not the question you wish they had asked you. So the oral argument starts, right now I'm going to talk about the plaintiff's attorney. So the oral argument starts. Judge Bill Pryor immediately asks the advocate for the plaintiff, there's no clearly established law here. Like, can you win? And he's very upfront and honest. He's like, Judge, you are completely right. We don't have an on-point case. And under most circumstances, that would mean we lose. But this very clearly falls within the obviously unconstitutional exception, and then mentions that a few 11th Circuit cases where it had been applied, and now none of those were exactly on point. But, first, he was honest with the court could trust him, and it was a good way for the court to feel confident that they weren't just making something up, like they do this when appropriate. Contrast that with the government's attorney, who, when she went up, essentially fought Judge Marquez constantly. She would not answer his question. Every time because remember, this is at the motion to dismiss stage. At the motion to dismiss, you accept all of the allegations in the complaint as true, and you draw all reasonable inferences in favor of the plaintiff. She was not doing that. She was fighting constantly. She was saying, well, yeah, it was tased, but it's a wild animal. You don't know what's going to happen. It's like the allegation in the complaint, it's that it is on the floor, whimpering, completely incapacitated. I don't care that you think wild animals are dangerous. That's not what it says. How do you get over this? And she refused to answer that question. And I think that really hurt her because, frankly, the court didn't trust her. Also, she was not applying the standard correctly.
Got to apply those standards, folks. Actually, to your point, Michael, I think it's interesting because we, of course, have this unanimous panel decision. And although Hope itself was not, I don't think, the Taylor versus Riojas decision was actually a per curiam unanimous decision of the U.S. Supreme Court. And there they said, hey, these prison conditions are so bad that it's obviously unconstitutional. And of course, if you're going to map prison conditions onto one or the other side of the political spectrum, I think you would be safe to assume that you're normally going to get less of a helpful hearing from the conservative side, and that was no problem in Taylor. And obviously, it's no problem here, even though that this is essentially, a police force case. Very different, given that we're dealing with a dog, as Radley Balco's reporting in the mid-early 2000s showed. If you really want to get people upset about police abuse, the dog videos and dog stories are the way to do it. But yeah, it's great to see a court, now the last court, say, A, you can't just shoot people's dogs, but B, also the obviousness exception to qualified immunity is a real thing, and we're going to take it seriously, at least in the cases where, it kind of leaps out off of the page. So with that, I want to thank everyone for listening to this special edition of Short Circuit Live from Arlington, Virginia, the birthplace of Five Guys Burgers and Fries. And I would like to say, as we go forward and you read circuit court opinions, just remember to get engaged. Thank you, everybody.